This meeting to order. Welcome to meeting number 52, the House of Commons Standing Committee on Justice and Human Rights, pursuant to Standing Order 108 and the motion adopted on January 30th, 2023. The committee is beginning its study on Canada's bail system. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to take a few minute comments for the benefit of the witnesses and the members. I'll pass on that. I think all of them are experienced members are online and witnesses here, so they all know how to use the Zoom functions. So for the first hour, we have the Honourable David Lametti, Minister of Justice and Attorney General of Canada. Welcome, Minister. We also have with him from the Department of Justice, Matthew Taylor, a frequent visitor here, a General Counsel and Director, Criminal Law Policy Section. So we welcome you both and glad to have you here. Minister, you have 10 minutes followed by questions, so the floor is yours.
Monsieur le Président.
Mr. Chair.
Vous le mentionnez.
Can you mention if it was done?
Yes, all the tests were done, and all the witnesses' sound tests as well as the members have been done. Thank you.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Now I can leave. I think my work is done here.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you to my colleague, Mr. Fortin, as well, for making sure that everything will run smoothly. And before starting, I'd like to mention that we are on the unceded territory of the Algonquin Anishinaabe people. And I also want to thank Matthew Taylor for being here with me today. Mr. Chair, I appreciate this opportunity to speak to the issue of bail and of a potential reform in Canada. I know this is an important matter that is of concern to Canadians. It certainly is a priority for my government that our laws be effective, fair, and that they protect Canadians while upholding the Charter.
First, I would like to express my condolences to the families of Constable Greg Piershala and Michael Finley, and to Katie Nguyen and all victims of disturbing incidents of violence across the country that we have seen in recent months. Each of these incidents has been a personal tragedy and a blow to our communities. I'm pleased to see this committee undertaking a review of all aspects of bail in Canada. Canadians deserve to be and deserve to feel safe. We all have a role to play in protecting our communities. I believe our bail system is strong and sound, but we are always open to suggestions for improvements, both in terms of law reform and ways in which we might better support the administration of justice and our police officers. The provinces have a key role to play in this issue. We've already seen British Columbia step up, and I'm encouraged to see that Ontario and Manitoba are also taking steps to improve their systems. I'm looking forward to meeting with Minister Mendicino and with our provincial and territorial counterparts this Friday to discuss bail reform and how we can all work together, collaboratively, to make Canadians feel safe. I plan to present what we are considering at the federal level and hope to hear from my counterparts what they intend to do in their space. In terms of the federal role, I want to reassure Canadians and emphasize that the law already tells us that if a person poses a significant threat to public safety, they should not be released on bail. There are no quick or easy solutions. That is why, at my direction, we began working on this issue months ago, again in collaboration with our provincial and territorial counterparts, to find solutions that will ensure the long-term safety of our communities. I think it's important to note that there's a data gap that risks clouding the issue. On the one hand, we've heard the opposition cite data that crime is up, particularly from people released on bail. On the other hand, data from the Toronto Police shows that between 2019 and 2021, there was a decrease both in the percentage of individuals granted bail and in the number of people rearrested while on bail. Dans la mesure où notre gouvernement
Insofar as our government always is seeking ways to improve public safety and the effectiveness of our justice system, I would be remiss not to correct the sources of much misinformation circulating regarding the former Bill C-75. Bill C-75 is the fruit of lengthy and close cooperation with the provinces and territories. The bill codified bail principles as articulated in the context of binding Supreme Court of Canada decisions. I would like to reiterate that Bill C-75 did not in any way, in any fundamental way, change the bail regime in Canada. The bill did not modify the tests upon which an accused may be released by courts, nor did it affect the fundamental rules within the regime. On the contrary, C-75 made the granting of bail more difficult in the context of some offenses such as intimate partner violence by going through reverse onus. It is simply false to allege that recent tragic incidents in Canada are attributable to Bill C-75. The matter is far more complex than a single bill, and it is extremely simplistic to claim otherwise. Our government is continuing its study and work on the system in a serious collaborative manner in order to find solutions that will protect members of our communities.
We are contemplating, which aligns with the request in the letter from the premiers, is to establish a reverse onus for additional offences. A reverse onus means that the accused will be denied bail unless they can prove to the court that their release would not pose a significant risk to public safety or undermine the public's confidence. This work is well underway. I also want to note that there is already a reverse onus on a number of firearms offences, including where an accused who is subject to a weapons prohibition is charged with a firearms offence. However, it is worth considering carefully whether circumstances in which we impose a reverse onus should be expanded. I look forward to discussing this further with the provinces and territories later this week. We've also heard calls from law enforcement for reform. I was pleased to have met with chiefs of police from across the country in February, and I'm grateful for their recommendations based on their frontline experience. Work is underway to develop legislative and non-legislative options to address the particular challenges of repeat violent offenders. I will also be raising these ideas with my colleagues on Friday. Nous savons aussi que ce n'est pas...
We also know that it is not solely through legislative reform that we can completely address this issue. The police needs the resources required to monitor those who are granted bail and to arrest those who breach their bail release conditions. We've already provided significant funding in this regard, and we are open to increasing that as needed. There also needs to be support and care for mental health, addictions, treatments. There needs to be a social safety net. The previous government cut social programs, and we note today the consequences of this. For our part as a government, we've made unprecedented investments in mental health, including $5 billion for the provinces and territories to increase access to care.
In British Columbia for the action they took on bail in November as part of their Safe Communities Action Plan. And Manitoba for funding new prosecutors to focus on serious firearms offences and violent crime. I encourage all provinces to use the many existing tools at their disposal to ensure bail laws are applied safely, fairly, and effectively. I've already connected with a number of my counterparts on this issue, as well as with leadership from national Indigenous organizations. I look forward to our continued discussions and collaboration. Addressing the particular challenges posed by repeat violent offenders requires a comprehensive approach that crosses jurisdictions and levels of government. We will be acting at the federal level, and I hope that my provincial counterparts will be willing to do the same. The only way to solve this problem is by working together. I'm hopeful that, together, we can build on months of joint work by federal and provincial officials and agree on a comprehensive plan forward. Nous savons.
We know that there are no easy solutions to such a complex matter. We firmly believe that we must protect Canadians.
We must ensure that any measures taken will not exacerbate the overrepresentation of Indigenous peoples, Black, or racialized Canadians in our jails. We must not further marginalize vulnerable people, including those struggling with mental health issues and addiction. It's a delicate balance, but one the government is committed to getting right. Thank you. Merci.
Thank you, Minister. We'll now go to our first round of questions, and we'll begin with Mr. Moore for 6 minutes.
Well, thank you, Mr. Chair, and thank you, Minister, as well as Mr. Taylor, for being here with us for this important study. Minister, before I begin on bail, quickly, when you were here 3 weeks ago, my colleague, Mr. Brock asked you about the very important matter of a charter statement on Bill C-39, which deals with your government offering medical assistance in dying to individuals who are suffering from mental illness. Do you have that charter statement completed yet? Because at the time you said we would have it very soon.
Point of order, Mr. Chair.
Yes, Mr. Nunzingard.
I think the issue of relevance is important here. The minister is here to talk about bail reform, and he will be back at a later time to discuss any other matters pertaining to his portfolio.
I will ask Mr. Moore to direct his questions pertaining to bail reform and trial, though you do have some liberty within that. But
Thank you, Chair. This is the first time the minister's been back since that last statement. The minister can handle himself. He's an experienced parliamentarian. That's my only question on that matter. So, Minister, is the charter analysis completed on Bill C-39?
I'm not sure what happened there. I'll come back to you on that, Mr. Moore.
Okay, it's important. So, Minister, I want to make sure we're on the same page. I know at times we're going to disagree on the right approach, but you have repeatedly, in the issue around bail and the issue around some of the entirely preventable tragedies that have occurred by repeat offenders who are inappropriately out on bail, you have said Canadians deserve to feel safe. My concern is, I think Canadians deserve more than that. They deserve to be safe to the greatest extent possible. Do you agree with me that Canadians deserve not just to feel safe, but in this country to be safe?
Well, certainly I've been saying publicly, and I just said it now, that Canadians deserve to be safe. And
You
they
said
deserve,
feel safe.
No, I said both. I can re-quote myself if you want, Mr. Moore, but I've said they deserve to be safe and to feel safe. And measures that we are taking, measures that we have taken, do their very best to ensure that. And I have committed to working with the provinces and with all of you around this table to bring any necessary changes to the federal part of the bail regime in order that Canadians be safe and in order that Canadians feel safe.
So, Minister, on that, when we hear your government and we hear yourself in question period on this matter, talk about the provincial role. The provinces, though, we need to make sure Canadians are under no illusion. The criminal code is the determinant on the law surrounding bail in this country, and all 13 premiers, and this is rare, but they have all together unanimously called on your Prime Minister to take urgent action to make meaningful changes to the criminal code to fix the current bail system, particularly concerning firearms offenses. And my concern is when we say, well, we all have a role to play. I think the big role here is your government and the willingness to say some offenders need, for the protection of Canadian society, when they're awaiting their trial, they need to be behind bars, not out reoffending. The case of Constable Pershall, a preventable tragedy. So are you listening to what the 13 premiers have to say when they say your government needs to fix the criminal code?
We're most definitely listening. Criminal code changes are one option, Mr. Moore, as you know. There are a number of reverse onus offenses already within the criminal code, including for a number of firearm offenses. We've certainly heard the suggestion that we try to focus on repeat offenders, and I'm open to suggestions on that, repeat violent offenders, as I've said in my remarks. But it is oversimplifying highly to say that it is simply changes to the criminal code that will solve this problem. There is a challenge and working with the provinces and with police forces in the administration of the bail system as well, and we are open to working with our provincial and territorial counterparts as well as police forces across Canada to make sure that we do a better job there too, and those areas largely fall within provincial jurisdiction. But the point here is that we have to work together.
Well, thank you, Chair. Minister, in 2019, you described the bail reform bill, Bill C-75, as I'm quoting you, an outstanding piece of legislation that goes a long way towards improving the efficiency, fairness, and speed of our criminal justice system. Yet the facts, and you mentioned some of the stats. If we believe Statistics Canada, and I do, violent crime is up. Gang-related murders are up in that time. In the last 5 years in Ontario, police have seen a 72% increase in cases of serious violence involving accused persons reoffending while on release for a previous serious offense. And, Minister, they lay the blame at the feet of your government on Bill C-75, which has made it more difficult to keep individuals, repeat violent offenders, behind bars while they're awaiting trial. Do you accept that criticism that's coming unanimously from every premier in this country that says the criminal code changes that you brought in, your government, are having a negative impact on public safety?
I don't accept that. Bill C-75 basically enshrined a number of Supreme Court of Canada decisions, which were already the law before that came into account. Bill C-75 added additional reverse onuses in the case of intimate partner violence. So again, helping victims in that regard. And the best thing experts will tell you in terms of helping the bail system is to help the overall efficiency of the criminal justice system. And Bill C-75, the primary function of Bill C-75 was to make the whole criminal justice system more efficient. Now, it hasn't had time to do its work yet. We're still working. We've had a pandemic in the meantime. But Bill C-75, it doesn't mean it can't be improved, and that's why we're here now. But fundamentally, it is a good piece of legislation, and it made it harder to get bail, and didn't change any of the fundamental underlying premises for bail that the Supreme Court had laid out.
Thank you. Thank you, Mr. Moore. Next, we'll go to Ms. Diab for 6 minutes.
Thank you very much, Mr. Chair. And again, welcome to you, Minister, and to Mr. Taylor. As we embark on studying bail reform here, I want to wish you and the Public Safety Minister, but also all the provincial territorial ministers, the very best as you all meet Friday. And I'm heard that you are also going to be speaking about what we're dealing with here today. But my question to you is, I agree that reforming bail reform in the bail system, there's many bodies and many actors that are responsible for that, and that we all have a role to play. I just want to ask you to either reiterate or re-emphasize or re-clarify the different bodies and actors responsible for maintaining an effective bail system here in Canada.
Thank you. That's an important question, and Mr. Moore got to part of it, but I'm glad that you have effectively finished the question. So, of course, the federal government has a role in the curation of the criminal code, in criminal prosecutions of other federal offenses that may not be in the criminal code, and certainly we have a role in other certain specified offenses in the criminal code and the prosecution of all offenses in the territories. So federal crowns do that, but the provincial and territorial governments are responsible for the administration of justice in the Canadian system, and so the vast majority of criminal cases are dealt with by provincial crowns, dealt with in provincial court systems as well. The provinces as well have the administration of the superior court system. So there's a great deal of work that is done by the provinces, and of course the police have a role because the police initially arrest and detain. And an officer has discretion to detain. Again, public safety is the primary criterion there, and flight risk, public safety, and making sure that everyone feels safe. And then if the police do detain, then it's a judge that will, or a justice of the peace or a judge who will hear the bail hearing on more formal grounds. So there is a large role that a number of different actors play, and of course, police have to enforce the bail provisions and conditions once they're put into place. And if there's a breach in those conditions, then of course the police come back into play again. So there is a great deal of work that needs to be done collectively working together. And the position that I have taken along with Minister Mendocino and our government is that we all have to work together in order to make the system work better at all levels. Again, in order that Canadians feel safe and in order that Canadians be safe.
Thank you for that, Minister. You also spoke about a number of initiatives provinces are taking. In November, British Columbia told Crown prosecutors to begin asking judges to refuse bail for repeat violent offenders awaiting trial on new violence or gun-related charges. Can you tell us if any other provinces or territories have implemented the same policies? And I guess as well, in your opinion, when you meet on Friday with the with the provincial territorial ministers, what would you be telling them? What can provinces and territories do to complement the federal government's action on bail? Or further do, I guess.
Well, thank you again. Great question. And I will be there primarily in listening mode. I've had some interaction with my provincial counterparts already, but certainly we want to hear what they think. British Columbia has taken an initiative with respect to repeat offenders, and that's critically important. That's something that they have raised from the beginning, well back in October of 2022, and are focusing on repeat offenders within the bail system, and that's something we can certainly take on. I mentioned Manitoba moving ahead with additional prosecutors, particularly for violent crime and weapons-related crime. In their bail system, and I know that Ontario is thinking of measures. I don't have all the details yet, and hopefully we will get all of that. The main thing, one of the main things we need is better data, and certainly something that I've spoken to my provincial counterparts about already, which is getting better data, particularly from police and from courts to the extent that it's possible, in order to get a more accurate picture. Right now we have competing data. They don't always go in the same direction, and it will help us on a policy level to get better data. But after that, working with the provinces, we also need to coordinate efforts. If in fact it's repeat offenders, if that's a place that we can make some changes to the federal criminal code to specify. I don't know whether it's a reverse onus or whether it's additional restrictions. We'll see. We're open to any good faith idea here with respect to repeat offenders. As I said, a number of weapons offenses are already covered by reverse onus provision. Are there other things that we might consider there? We'll see, but we'll work with the provinces and build on their experience on the ground in the administration of justice.
Minister, thank you. Do I have any more time? If I do, I guess I'm curious, as an Atlantic Canadian, have you heard from the Atlantic provinces?
I have spoken to my counterpart in Newfoundland and Labrador, but I will look forward to hearing from the rest on Friday.
Thank you, Ms. Diab. Next, we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. Minister, thank you for being here with us today. Minister, I heard you say this, and I think you're absolutely right, that the administration of justice is a provincial area of jurisdiction in Quebec, as far as we're concerned in Quebec. Would you be able to agree to this, that the administration of justice includes, anything relating to hiring justices, judges, managing the courtrooms, etc. But when we're talking about bail release, for instance, among other things, all of the judicial work that has to be done must be done with absolute respect for rules and laws, and specifically in this case of the criminal code. Absolutely, yes. We have that as a responsibility at the federal level. This is not something we exercise alone. As I said, Bill C-75 at the time was the product of cooperation between the provinces, the territories, and the federal government. It was the same in the case of the bill on reforms to the other provisions in the criminal code. It's important to look at the resources the provinces have to do the work. Of course, we're open. No, sorry, Minister, I'm sorry I'm interrupting you, but you know how things work. We have very limited time. But what I'm gathering is that you agree with this, that the provinces, like Quebec and territories, administer the judicial system, the service, in respect of the criminal code provisions. You say C-75 is the fruit of cooperation with the provinces and territories. Sure. But at the end of the day, it is the federal government's responsibility. It's your government that put forward C-75 and that supports the criminal code as a whole. The criminal code, I mean, correct me if I'm wrong, but it is in the image of what your government believes to be the best rules to apply in the criminal sphere. Am I right? Or am I wrong? No, you're not at all. You're not wrong. You're right. But it is not a sole responsibility for us. We don't do this on our own. Yes, Minister, but we're here to discuss bail conditions provided under the criminal code and out of, I'm not sure if you're not eluding the question here. Forgive me if I'm wrong, but you say, there are administrators in the provinces and territories. There's the staffing of the system. Sure, but the rules that all of these people apply are the ones that you dictate, Minister. And therefore, I find it would be interesting to look at these very rules. Now, there's talk of potentially changing the bail regime. And here we realize that the last few months of your government have led to more liberalism of these provisions, especially with respect to the concept of restraint, the principle of restraint. The principle according to which the judges have to release people as soon as they have the opportunity to do so, so long as they respect a number of conditions. Very well. Then we were looking at mandatory minimums, which were, in some cases, many cases, repealed. And we realized that some offenses, firearms-related offenses, for instance, firing a firearm with the intent to do so. So there's no more mandatory minimum on that, which has led to accused individuals saying, well, listen, the legislators thought that it was not that problematic. There's no more mandatory minimum for this one. Or, we've seen this with sex assaults. And, you have conditional sentences in some of these cases. And I think this creates a climate, you'll correct me if I'm wrong again, of a sort of a climate of greater freedom and minimal rigor when it comes to accused in this criminal context. When we talk about interim release or judicial interim release, do you not think we should be a bit more reluctant to broaden that, and we should in some way attempt to think again about some aspects of mandatory minimums and conditional sentences to avoid the mistakes that have occurred over the last few months? Thank you for the question. I'm quite delighted to have an opportunity to correct you. Mandatory minimums have not succeeded. It was an absolute abject failure for the Conservative government. The conditional sentences exist to combat overrepresentation of Black people and Indigenous people within the system. Serious crime always deserves serious punishment. In our system, we give the judge the power to apply the law as it is. I am not the originator of C-75, Bill C-75 is not the origin of a person being found guilty before being proven innocent. There's a basic presumption when it comes to bail. What Bill C-75 did was to create a framework for both common law and the Supreme Court, as interpreted by the Supreme and the Criminal Code as interpreted by the Supreme Court of Canada. Bill C-75 did not change that basis, nor the large. Sorry, Minister.
Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I thank the Minister for being here. I've said before, I think we're kind of three different levels of concerns that we're talking about with the bail system. We're talking obviously about legitimate public concern about violent offenders who reoffend while on bail. We're also talking about a lot of low-level, repeat what I'd call public order offenses that legitimately threaten some people's safety. And then the third that I don't think we talk about is the overrepresentation of marginalized peoples, including Indigenous people, in detention before trial. And in 6 minutes, I can't ask you about all three. So I think we'll get lots of other witnesses. We can talk about the lack of mental health programs, the lack of addiction programs that are the cause of a lot of the low-level public order defenses. So I want to ask you about the other two. In terms of your openness to creating more reverse onus offenses, one that strikes me that currently does not have reverse onus is the unlawful possession of a firearm which is restricted and prohibited along with ammunition. So in common language, having a loaded gun, prohibited a restricted gun in public. That's not a reverse onus offense. So would the government be prepared to add that to a list of reverse onuses for bail?
Thank you for the question. Certainly, we'd be willing to consider that. I mean, we're going to meet with our provincial counterparts in good faith and see where we might make changes. Remember, we're working in the context of the Charter, and if everything has a reverse onus, it's quite likely that at some point we'll pass a tipping point in which the courts will not find favor. Because they will say the person's right to bail has been breached, but certainly willing to look at that and in good faith.
Well, of course, the courts have upheld reverse onus in all the cases that have been tested so far, I believe.
That's right, but as I said, at some point we may reach a tipping point.
Okay. At the other end of things, we do see the overrepresentation in detention of marginalized people, and I think people sometimes forget, first of all, that people are innocent, haven't been convicted of anything, and secondly, that when you're in detention before trial, there are no programming options available to people. Generally, there's no counseling, there's no addiction programs, there's no nothing while you're awaiting trial, and because of delays in our system, that can take literally months and months. So I know this is not a solely federal responsibility, but I think we have a problem here of a lack of community-based bail supervision programs that would allow people to be out who shouldn't necessarily be in, and so to keep their employment, keep their housing, keep their custody of their children. If they could have proper bail supervision, how does the federal government feel about that lack in many, especially rural and remote communities?
Well, again, we're certainly willing to work with provincial and territorial governments to look at those kinds of options moving forward. When I talk about the system, we need to be looking at all parts of the system. Most people incarcerated are actually awaiting trial. Those people are all legally innocent at that point. A number of them are not factually innocent necessarily. We know that, but a large number are, and a large number are legally innocent. And so we do have a responsibility to work to create that kind of programming. Again, bail is, you're not supposed to get bail if you represent a flight risk, if you represent a threat to society, or there's some other reason that would bring the administration of justice in disrepute. Most people do not fall into that category, and therefore we need to work together with the provinces and territories to ensure that we have a system that works, not just in terms of the bail parts itself, but for the people who are awaiting trial, who are within their communities, trying to keep them integrated in their communities in a way that's safe for everyone and productive moving forward.
One of the things that C-75 did was try to establish a better link between conditions for bail and the actual offenses. And one of the things that I think we see quite often is that bail conditions lead to an offense, but because of that breach, which brings people into the system even ever more tightly each time this happens. So one of the things that's quite often still is that abstinence from drugs or alcohol is listed as a condition for bail when we know that people with addictions can't possibly meet that condition. So how do you think we might be able to address that problem and that C-75 started down that road?
Well, I think we need to continue trying to implement C-75. I mean, part of C-75 was precisely to make sure that bail conditions were linked to the goals that we had in the system, keeping Canadians safe, preventing recidivism. And so we need to continue in that light. We also tried to make sure that the so-called administration of justice offenses didn't become a reason for someone to enter into the revolving door of the bail system and the carceral system in a way that in no way protected the safety of people. And it did have an impact on Indigenous and other racialized Canadians in that regard. So it's going through with the reforms at C-75 as a first step, and then reevaluating and seeing where we are.
Great. Thank you.
Thank you, Mr. Garrison. We'll go to the next round for 5 minutes with Mr. Caputo.
Thank you, Mr. Chair, and thank you, Minister, for being here. It's always a pleasure to have you here. Do I have it right that your testimony before committee today is your belief that Bill C-75 made it harder for people to get bail? Do I have that correct?
Well, it framed a number of Supreme Court decisions that already existed, and it made it harder for people to get bail in cases of intimate partner violence.
Okay. So are you saying then that less people should have been getting bail based on Bill C-75? Is that your position?
Now, what Bill C-75, in terms of serious offenses, Bill C-75 didn't change anything and made it harder for people in cases of intimate partner violence. What Bill C-75 tried to do was that the case of administration of justice offenses, so missing a bail hearing, those kinds of minor offenses,
right.
Those were meant to not be a point of entry, a larger point of entry into the criminal justice system.
But when it comes to serious offenses, since Bill C-75, we can agree, and in the last 5 or 6 years, 7 or 8 years, really, more people are getting out on bail for serious offenses. You'd agree with that?
Well, there are contrary statistics. Toronto's police statistics from 2019 to 2021 are I think, pretty accurate.
You did cite those, but they're accurate. But there was also a pandemic at that point, Minister, and jails were overcrowded, and people were worried about getting COVID in jails. Okay, we can't compare apples to apples. We got to compare apples to apples here. So if we're talking about a pandemic, that's a lot different. Have any police officers told you it is harder to keep people, it's easier to keep violent criminals detained? Has any police officer told you that in the last few years?
Again, there are countervailing statistics and countervailing narratives.
I'm not talking about statistics, Minister.
I'm here. Well, I have mentioned as I think an important priority that we get better data.
I'm
and
asking
we're working
about
with the provinces to get better
what's happening on the
data.
street. If you want to know what's happening, you ask the people who are impacted. The police officers on the street, are they telling you, as Minister of Justice, that it is now harder to get bail than it was 5 years ago?
I expect to hear a certain narrative from police officers who do their job very well. There are other actors in the system who also give a countervailing narrative.
Minister, I'm not asking you about narratives. I'm asking you what police officers are telling you, the people who put their lives on the line every day to keep us safe. Are they not telling you that it is too easy, people are getting bail who should be detained? Are they not telling you that?
We are listening to police leadership across Canada. They have recommended a number of options. They've also recommended some things that are reverse onuses that are already in the criminal code.
Well,
so we're
mindful
listening.
of that, Minister.
We're very much listening, and we're working collaboratively to get to a solution.
See, but Minister, here's the problem. Constable Pirjala was killed on December 27th. Before that, for months in the House of Commons, it was raised day after day after day that catch and release isn't working. And you come to the committee today and say, we're working on this. I put together a bill, Bill C-213, in about 2 weeks after that. You have an army of lawyers behind you and policy advisors, and yet you still haven't acted. And I find that disheartening. Now, when it comes to Bill C-313, Minister, I know that you said that you were prepared to work with me. Just for the record, I haven't received my invitation. Are you prepared to provide an invitation to opposition parties to work with you on this point?
Yes, and let me answer the other part of your question since you raised it. It is categorically wrong to say we have not been working on this. Since October, we have been at the deputy minister level. We have been working with the provinces and territories on bail reform to look at what we might do. Yes, Constable Pierre Chala's death was a tragedy. It was a tragedy, particularly because he was out on a bench warrant, and so he had breached.
But he was out on a bench warrant after a bail review. So let's not split hairs here. He was released by a judge.
Will you let me answer the question?
Well, no,
Yeah.
we've got to talk with facts. Here.
Yes, there were a number of different hearings, but he did materially breach the last order that he had, and it's sad that tragedy happened.
It's not. It's more than
but it is
sad.
categorically
Minister,
wrong.
I have
It is
30
categorically
seconds.
wrong to say, Mr. Caputo, that we have not been working on it. We have been working on it.
Well-
We have been working on it with the provinces and territories, and in fact, we're going to meet on Friday.
I have 30 seconds left, Minister. I will ask you this. When was the last time you personally sat in bail court to watch bail hearings take place so you could see what was happening on the grounds?
That's an irrelevant question.
No.
Mr.
It
Caputo.
is completely relevant, Minister.
I have to rely. I currently have a role as a member of Parliament, as the Minister of Justice and Attorney General. I have a number of different things that I have to do.
You're not going to tell us the last time you
I
sat in
rely
bail
on the
courts.
expertise of
You're the
people
Minister
within
of
my
Justice.
department.
You should be watching
And
for yourself, sir.
I am watching very carefully, Mr. Caputo.
Thank you, Mr. Caputo. We now go over to Madame Briard for 5 minutes.
Merci, Monsieur le Président. Bonjour, Monsieur.
Thank you, Mr. Chairman. Welcome, Minister. It's always a pleasure to have you here. You're right. You mentioned earlier that there was no easy answer to such a complex matter. I am quite concerned by the issue of protecting victims and their safety, the safety and security of the public as well. I'd like to hear what you would think Bill C-75 did, in which way it is aligned with the Supreme Court's decisions. And you also earlier you spoke to our colleague in saying that we can't forget that we're working based on the Charter. There was also some talk of the presumption of innocence. So there are four aspects to my question. Thank you very much for the question. As I've said, Bill C-75 is the result of close cooperation between the provinces, territories, and the federal government to pull together the best ideas in reforming the criminal justice system, including the bail system. So we really gathered the best ideas at the time, and it was a bill that created a framework for a number of Supreme Court of Canada decisions specifically relating to bail release. So in that regard, it did not change the basis upon which, or the most important regulations or the architecture within the system. It was really more of a clarification of principles that were provided by the Supreme Court. There's also the aspect of addressing overrepresentation among Indigenous and Black people within the system, specifically for minor offenses against the administration of justice, for instance, someone who perhaps didn't show up at a hearing because of an issue of distance or other, and the idea of harmonizing the conditions with the real problems. This is a reform that was supported by provinces and territories at the time. Of course, there is a challenge given some situations we've seen, and we are prepared to review the whole thing and see how we could further improve the bill or the law. Thank you. And what would you say to someone who says that C-75 has actually weakened the bail system? That's patently false. As I've said, specifically when it comes to serious offenses, firearms-related offenses, as an example, We created a framework for those Supreme Court of Canada decisions. There already were reverse onus provisions in this case. We also added another reverse onus provision for intimate partner violence. And so for serious cases, it was at least as difficult as before and even harder to get bail, to be granted bail. So I think the bill was positive and valuable. And of course, now we're looking to see how we can improve it. On that point, on the issue of intimate partner violence, what is our government doing to fight intimate partner violence and protect victims from these intimate partners? As I stated in Bill C-75, we reversed the onus to help victims, to make it more difficult for individuals to get bail or be granted bail in these conditions. We also better defined in Bill C-51, there are some definitions of sexual violence. And with former Bill C-3, we'll have better training for judges to better address the issue of intimate partner violence and sexual assault. We support victims in a significant way throughout Canada through our programming, and we remain open to bring about other changes when it comes to intimate partner violence. There are other bills. I know that one member here present put forward a bill on coercive control, and I publicly stated that I would support such a bill. It's very important also to define the offenses in a comprehensive way for the victims that themselves are experiencing these situations. Thank you very much.
Thank you, Madam Briard. Next, we'll go to two and a half minute rounds, beginning with Monsieur Fortin.
Merci, Monsieur le Président. J'ai 2 minutes.
Thank you, Minister. I have 2.5 minutes. First off, I fully agree with the principle of giving judges some latitude. I trust our legal system, our justice system, and I like the idea that some previously passed provisions exist to improve training for judges in various fields. And that is, apple pie in a way. We all agree on this. Nevertheless, the legislator sends messages to the courts when judges have to make decisions. They rely on the legislator's decisions. And you know as well as I do that they have to interpret legislation. I was saying earlier that now there's some liberalization, if you will, of some aspects of this, and the mandatory minimums have been struck in some cases for serious offenses like discharging a firearm, as I said, with intent. Another case would be for sexual assault cases, and that to me is a message that is in a way counterproductive that we're sending to our courts. Do you not think it would be wise to get back to some mandatory minimums in those cases, in the cases of those types of offenses, so that there are no conditional or sentences or those served at home, but also giving judges the capacity to not apply mandatory minimums in specific exceptional circumstances, asking, therefore, the court to justify that. And what that would mean is that you would avoid conditional sentences. The public would be reassured. There'd be a clear message sent to the courts that we take these offenses very seriously. Would that not help when it comes to bail, for instance? Would that not help the courts better grasp the seriousness of the offenses? Thank you for the questions. Judges never have to apply that. They can't go below the mandatory minimum. No, but they can go in the other direction. Yeah, but that's not what we're talking about. Sure, but it's important to mention it. Come along, Minister. I have a few seconds. Yes, but I'm being serious, says the Minister. What we changed had to do with firearms that were hunting rifles. We did not affect prohibited weapons or offenses that are relating to organized crime. The message is very clear. And in fact, we're increasing maximum sentences under Bill C-21 for organized crime-related firearm offenses. So we're only supporting a small number of offenses that have to do with hunting rifles. I think the message is rather clear. Serious offenses deserve serious consequences. Justices have that option at all times.
Thank you, Monsieur Fortin. Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair, and I thank the Minister for his expression of support for my private member's bill, C-202, on coercive and controlling behavior. And I've also been working very closely with the member for Victoria, Laurel Collins. And so our commitment as New Democrats is we will get this bill before this Parliament, one way or the other, soon. So I thank you for your mentioning of that. I want to return to the issue of bail hearings directly. One of the things I hear anecdotally is that often those who are asked to make the decisions don't have full information in front of them. And Section 518 of the Criminal Code allows prosecutors to present evidence about previous offenses and other relevant circumstances, but it doesn't require presentation of that kind of evidence. So again, one of the suggested reforms is that we amend the Criminal Code to require in every bail hearing the judge have in front of them information about previous offenses by the person who's seeking bail. Is that the kind of thing the government would be prepared to consider in reform of the bail system?
Certainly would. Anything that helps make that helps a better decision to be made, to be taken, particularly when the security of the public is at risk. Another thing that I also be interesting is there a role for victims to play at the determination of bail in the evidence that's tendered? And so, again, what we are trying to do is to keep an open mind to positive reforms that can be made. Again, in order to keep the public safe, in order to prevent recidivism, protect victims and communities. But also not incarcerate someone who doesn't present any of those risks to society.
And again, we have, certainly in my community, lots of anecdotal evidence about conditions still being imposed, like a curfew or like not being in certain parts of town or not associating with certain people, which sets conditions for those in particular who are homeless or with mental health issues, sets conditions which they can't possibly meet. I have a staff member who was formerly a case support worker for someone whose mental health problems literally didn't allow them to tell time correctly. Yet they were forced to report at a certain time every day. Right. And we still have those kind of conditions being imposed, and that led to further involvement in the justice system.
The spirit of Bill C-75 is that those conditions should not be imposed. There shouldn't be anything there that isn't in any way linked to the crime or those other standards, recidivism, public safety, etc. We need to keep working at the mise en oeuvre of the implementation of the bill.
Thank you.
Out of time. Thank you, Mr.
Thank you, Mr. Garrison. Thank you, Mr. Lametti and Mr. Taylor for coming. And once again, you're always a pleasure to have you. We'll now just suspend for a minute or two while we get our next witnesses, who I believe one's online and two are in the back. this bail system, and I'd like to welcome, if I get this title right, is it Superintendent Sidney Leckie, Commanding Officer of G Division, Royal Canadian Mounted Police, and I think you're doing it by video conference out of beautiful British Columbia. Oh, sorry, Northwest Territories. My bad. I was a little excited that it was British Columbia, but that's E Division, your G Division. We have Chief of Brantford Police Station, Robert Davis. Thank you for coming. And Chief of the Six Nations Police Service, Darren Montour. So welcome. We're all glad to have you here. You each have 5 minutes, followed by the usual round of questions. And I'll begin by Superintendent Leckie, the Commanding Officer from Northwest Territories.
Good day. Thank you. Good afternoon. Thank you for the invitation to appear before this committee today, along with my law enforcement colleagues as you study Canada's bail system. I am Chief Superintendent Sid Leckie, a member of the Royal Canadian Mounted Police and Commanding Officer of G Division in the Northwest Territories. As a member of the Piscatamakati Nation, I would like to acknowledge that I join you today from Chief Dragi's territory of the Yellowknives Dene First Nation. I have been in my current role since October of 2022, prior to which I was the officer in charge of the Kamloops RCMP detachment, with responsibility for policing services to the city of Kamloops, but also a large rural area including 3 First Nations communities. The RCMP is supportive of a balanced approach to bail reform that considers community and officer safety, overrepresentation of racialized people in prisons, and the rights of the accused to be presumed innocent until proven guilty. I am here today to share some of the impacts on our communities that highlight the need for bail reform to address not only public, but the officer safety risks caused by releasing violent offenders and repeat offenders in our communities on bail while awaiting trial. The RCMP is all too familiar with the incidents and risks chronic violent offenders can have to public and officer safety. In the past decade, the RCMP has seen the murder of members Constable David Wynn and more recently Constable Shaylin Yang by chronic violent offenders. Information obtained from one of our 11 divisions that provide frontline policing found that of the 91 homicides in that division in the past 3 years, 48% of individuals accused were subject to police or court-imposed conditions. Just over a week ago, a member was shot at during a police traffic stop and exchanged gunfire with the suspect. The accused had been released 2 weeks prior on a $1,500 cash bail with conditions not to possess a weapon. The outstanding charges included violent crime and 4 firearms offenses. While not to diminish from the focus on violent crime, it is the effect of what is commonly referred to as low-level or property crime that has been the most impactful to citizens in many of our communities. Having met with mayors, First Nations councils, business improvement associations, and community groups, they express a feeling of lawlessness. They regularly question why offenders are being arrested and released multiple times only to reoffend, and the term catch and release is often used to describe the cycle. The prevailing message is that what has been considered low-level crime for some is not for many who are victimized repeatedly. And this is often at significant expense to the business community who express anger and feel let down. The repeated cycle of arrest and release has had a significant impact to many involved in the justice system, adding workloads to police, clerical staff, and all participants who would handle the volumes of documentation that follow. Many of these policing costs are borne by the communities. I have also observed that the administration of justice charges that accompany repeat offenders are seldom prosecuted when recommended by police. These include breach of undertaking, breach of probation, and fail to appear charges. These are key grounds allowed for in the criminal code to show cause for detention. In one city, 50% of failed to comply with undertaking charges have been stayed, withdrawn, or dismissed in the past 3 years. As highlighted in recommendations from different police associations, bail reform offers opportunities to consider tightening the rules on the use of sureties, expanding the use of reverse onus conditions for offenders, and expanding the use of electronic monitoring where practicable. Under the Police Services Agreement, the RCMP provides frontline policing for about 22% of Canada's population, and about 75% of Canada's geographic landmass. This includes policing services for many of our Indigenous communities. And with this in mind, the RCMP would welcome a holistic, trauma-informed approach to bail reform. From experience, it is often our Indigenous and marginalized community members who are most at risk by violent offenders, often in remote and isolated communities. I thank you, and I look forward to your questions.
Thank you, Chief Superintendent Leckie, and now we'll go over to Chief Robert Davis for 5 minutes.
Thank you very much for the opportunity to be here today on this very important topic about bail reform. My name is Rob Davis. I'm the Chief of Police for the Brantford Police Service. I am very proud to be a Mohawk from the Six Nations of the Grand River. That's where I was raised. And throughout my policing career, I've had the opportunity to serve in several police organizations across Ontario, in the far northwest, in the isolated communities of Anishinaabe-Aski Nation, as well as my career has taken me to Alberta, where I served in the Lethbridge Regional Police Service, and then I returned back to Ontario. I was also seconded to the RCMP for 5 years. That took me across the country to train police leaders, and so throughout my career I have a unique lens of how the justice system has rolled out in different provinces. I have also consciously, in every move that I have made, gone to positions where I could stay very involved with Indigenous policing, whether it be on reserve or in an urban setting. And it's I bring that experience here because as we talk about bail reform, I have witnessed firsthand how Gladue considerations, which were initially to be used for sentencing, are now impacting the bail system. And to be quite candid, are being, I would say, exploited. It's far too easy for an accused to claim that they have Indigenous heritage and thereby be given consideration. I've also observed that in the bail system there is a lack of scrutiny on the sureties that are put forward quite often that has become problematic. The events of Constable Greg Percella's death are very tragic. And in the earlier session, Mr. Caputo asked, what are the officers saying? What are the officers saying on the street? I'm going to provide you an example of what's happening, and you can hear it from this officer. In the community I serve of Brantford, Ontario, on February 12th, our officers were sent to an innocuous call. Somebody passed out in a car, in a taxi cab, at 4:45 in the morning. Upon arriving, they wake up the individual, they identify the individual to find out that they were on a release order from January 12th of 2023. They were to be in the residence at all times with their surety and were blatantly violating it. Upon arrest, they were searched subsequent to the arrest, and a loaded firearm was located in the pocket of this individual. It was fully loaded with extra ammunition readily available. The person was held for bail, and as far as the latest update I have is that he has since been released. What really sent chills up my spine is that this location is literally 35 kilometers from where Greg Percella was killed. 20-minute drive, 10-minute drive, lights and sirens if we were lucky. And it's disgusting that this event happened 47 days after his death. Commissioner Creek has said Greg's death was preventable. And here, 47 days later, my officers are responding to the call at 4:45 in the morning in a city that is a commuter town to the GTA. There's a lot of people up in Mobile at that time of day. And here is somebody who the justice system has allowed to be out on bail, carrying a firearm, fully loaded. And let's not lose sight of the fact of their lengthy criminal history that included numerous firearms offenses, violence, and a lifetime prohibition. The similarities of this individual are eerily similar to the circumstances of Mackenzie and Constable Percella. So to Mr. Caputo's question earlier about what are the police officers saying, Mr. Caputo, the system's broken. People like this are getting out on the street, being released, being held for bail. The police are doing our job, trying to do our job, and then when we have them put before the courts for bail to be held in custody, they're being repeatedly released. What is also concerning is that the people see this, the citizens see this, the taxpayers of this country see this, and they're losing faith in the system. I hear from citizens all of the time that they are losing faith in the justice system, and my biggest fear is that this may eventually lead to vigilantism. People will take measures into their own hands to feel safe. And so I look forward to your questions. Thank you.
Thank you, Chief Davis. Next, we'll go to Chief Darren Montour for 5 minutes.
Thank you. Thank you for the invitation to appear here before this committee. A lot of what Chief Davis says, I echo wholeheartedly. Chief Davis and I policed together on the Six Nations territory growing up. I grew up there. My whole career has been spent on Six Nations of the Grand River. I am Mohawk. I am the Wolf Clan. I am very passionate about keeping my community safe. And as Chief Davis said, as Mr. Caputo said, the system is broken. I look at December 27th, 2022, the death of Greg Berchella. I didn't know that young man, but he policed with my officers junior to me. One of those officers working that day was my nephew, and he had just started policing on the Six Nations of the Grand River Territory. He worked his way from his teenage years to become a police officer. Our acting deputy chief, his son was also working that day, so it could have very easily been one of the Six Nations officers who lost his life that day in such tragic circumstances. And I go to the Gladue factors as well, because looking at the history of Gladue, don't get me wrong, it does work in certain circumstances, but I'm going to quote here, for repeat violent offenders seeking bail, the Gladue factors, in light of everything that's been going on, speaking with Chief Davis's latest individual who's been released, Gladue factors are outweighing public safety. And going forward, I hear that from my community. I hear that from elected council members. They look at Gladue as the get out of jail free card. And in my opinion, I've said this to the media on a few occasions, that race should not play a factor in the bail conditions of repeat violent offenders. And I pose a question, if Randall McKenzie was not Indigenous, would he have been released that day? I don't know, I cannot answer for the justices involved, but in my opinion, seeing his criminal record, he was to reside on Six Nations of the Grand River Territory. His surety wasn't the utmost choice that I would have made, but again, that's decisions that were beyond my control. And my officers are responding to calls when he's tampering with his ankle bracelet, and then he's gone into the wind. 25 minutes is the response time. By the time we get there, he's gone. And jump ahead to October, he's wanted again by the Hamilton Police Service for other serious offenses involving a firearm, domestic. We check and we go knock on the door again at his surety's place in Ohsweken on the territory. His mother advises us she had not seen him since he cut his bracelet off in July of 2022. Jump ahead to December 27th, and we have the shooting of Constable Berchella. And to me, that really hit home based on what I've told you earlier of who was involved. I was on the ground that evening, geared up in my uniform, my firearm, with my fellow officers helping the OPP effect this arrest of this individual. So it is heartfelt for me. It is close to home, and I hope that something changes. And Chief Davis and I, like I said, we're friends. I know a lot of members of the OPP and the Haldimand County Detachment who are having a very emotional time right now, and to me, that is totally warranted, because this has to change. Something has to be fixed. Thank you.
For our first round of questions, beginning with Mr. Brock for 6 minutes.
Thank you, Chair, and thank you, Chief Davis and Chief Montour, as well as Superintendent Lucky, for your attendance today. This is an extremely important topic that we are trying to produce a report to the House of Commons to effect change. It's near and dear to my heart, given my previous career. So I'm going to try to split my time as equitably as possible, but I'm going to start my time with you, Chief Davis, We've heard from the Minister of Justice, also known as the Attorney General, Canada's chief lawyer, chief prosecutor, who made, in my opinion, some pretty inflammatory comments. Comments that would only come from an academic. And that's his background, academia. He taught law. He did not practice law in the trenches. We have a couple of prosecutors on this Conservative team right now. I want to separate theory and academic from reality. Some topics, some lines that the minister uses as follows. Our bail system is sound and strong. That there's a law that already tells us that if the accused is a threat to public safety, they should not be released on bail. It's erroneous to attribute recent events, such as the killing of the OPP officer, to Bill 75. That Bill 75 made it harder to receive bail, and that individuals are not supposed to get bail if they fall within the enumerated classes under Section 515, a flight risk, a danger to the community, and where the administration of justice would be brought into disrepute, known as the tertiary grounds. That's theory. Let's talk about reality. What do you say?
Thank you, Mr. Brock. The example I gave, I think, speaks volumes. Greg Porcello was killed December 27th. The individual in the example I gave had committed an offense, was held for bail on January 12th, released, violated his bail when the officers in Brantford dealt with him on February 12th. A lengthy record for violence, firearms, conviction for manslaughter, yet he was out on bail. And so the reality is that it's not working. And let's go beyond the focus is about police officers now because of the deaths, and I get that. But in this situation, this was a person passed out in a cab. So what about that poor cab driver who's out there trying to make a living and the risk to their safety and to the average citizen's safety in this country?
Hey, quickly, in my previous career, I often heard the phrase that the accused know how to game the bail system. Can you elaborate on that in the context of the application of GLADU?
Quite candidly, people will, through their lawyers, will shop. They'll shop for a justice of the peace that's going to be very lenient with the GLADU considerations. And the minute that they identify as being Indigenous, there's a very high likelihood that they're going to be released with minimal conditions. And so you see this shopping quite regularly.
Over to you, Chief Montour. I don't know if this was attributable to you or to Chief Davis, but GLADU is being exploited. Please expand upon that from the perspective of the accused, but more importantly, from the perspective of the community.
From the perspective of the accused, as Chief Davis said in his opening statement, there's no proof for these offenders to prove that they are Indigenous. They're taken at their word. And there are individuals...
Can you elaborate on that, please?
What
does that mean? They're just taken at their word.
They provide no proof as to if their identity of they are Indigenous. They could have great-grandparents who are Indigenous, and that factors into whether or not they receive bail based on the GLADU factors. And to me, I got to ask how many generations since the residential school factors in for those people undergoing intergenerational trauma. Some people are using this as a crutch. And to me, it hits home because of the people that we deal with on the territory. We know our community. We know who grew up there. I know practically all of the people my age. If I don't know someone, the younger generation does. And yet we hear of these people explaining to or saying to justices of the peace that they are Indigenous, through their lawyers, of course. And to me, I scratch my head to say, is there no proof that this has to happen where they provide some sort of background information of their ancestry?
Okay, thank you. Over to you with my time remaining, Superintendent Leckie. I was quite interested in your commentary with respect to the number of breach charges, undertaking, recognizance, breach of probation, failing to appear, key grounds that will allow any justice or judge to detain an individual. And you cite in one particular city, 50% of those charges are being stayed, withdrawn, or dismissed. What does that say? What kind of communicative piece is that giving to offenders across this country, but particularly in your jurisdiction?
Your mic's off, Chief Lucky.
Thank you for the question, Mr. Chair. It is one of the frustrations for police officers that's been expressed in my time with the BC Association of Chiefs of Police and many of the colleagues that we work with, that it is quite often that charges that are proposed, such as failing to appear or many breaches, are either dealt away or charges are stayed. It's very frustrating because those are the very charges that are used to support holding and detaining a client in custody. So it becomes that much more difficult to be able to proceed if you can't. Some of the very grounds that we would use when all the other tools have been reduced and or taken away, again, that's just another tool that's been made less effective, which means that offenders will not have that on their criminal records when judges use or JPs use that for consideration in bail. So it exacerbates the problem of what we would consider the repeat offenders being released and rearrested.
Thank you, Chair.
Thank you, Mr. Brock. Next, we'll go over to Madame Briard for 6 minutes.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair.
Have the translation? Okay. D'abord, j'aimerais.
I'd like to start by expressing my compassion for the loss of your colleagues and to express that I feel it must be very difficult to work in the conditions that you're working in. I'd like to thank you for the work that you're doing. Mr. Leckie, my first question is for you. In your opening statement, you provided some statistics about one of the 11 divisions providing for frontline services, police services. Do you have any data for the other divisions?
Thank you for the question, Mr. Chair. The short answer is that the RCMP is in the process of collecting and collating information as we speak. That information will be supplied to our public safety minister to assist him and the Justice Minister as they move forward in the bail reform process.
Merci.
I don't have any others at this time.
Okay, merci.
Okay, thank you. Earlier, we were hearing the minister say that these were not just it wasn't just legislative provisions that were required, but there also needed to be support for mental health and addictions. Could we start with you, Mr. Davis? Can you tell us about the impact of these types of having people not released because they have issues of addictions, etc.?
Can you clarify the question, the impact on the offender, can you clarify that, please?
For the individual who is being detained, could you tell us about the impact that may have when the individual is dealing with a mental health issue or an addictions issue?
The comment was made earlier that there's a lack of services available while people are being held in custody, pretrial custody. And I would suggest that that is accurate. That's an accurate statement. But it's also been my observation, even if a person's convicted, there's still a shortage of services in the institutions. So the impact on the offender is that they're still in crisis, if you will, having to deal with the addiction issue or the mental health issue. And so incarceration is not necessarily the answer, but it has to be done on a case-by-case basis. We have to do the analysis on a case-by-case basis. And that's where we have to always put public safety and the risk to the community, I think, has to be paramount.
Merci beaucoup. Chief Montour.
Thank you very much. Chief Montour, would you have anything to add?
I echo Chief Davis's comments there that we look at the mental health stability of a person upon arrest, if that's the case. If it's more stringent that they seek medical professional help for their mental health status, we ensure that they go for a mental health assessment first. And as far as the addiction issue goes, we arrest, we charge, and I know firsthand, dealing with certain individuals, that addiction is still there. So to me, this becomes a community initiative to where agencies, I'm speaking specifically for Six Nations of the Grand River, have to work together. Enforcement is one spoke in the wheel. We enforce the laws, charge accordingly, and ensure the safety of the community, whereas social services, health, Six Nations mental health come into play here, is having a community type process to where we can actually help those individuals, because obviously they are in a crisis at the time that we deal with them, and we want to ensure that the public is safe for one thing, as well as those individuals. So it's, like Chief Davis said, every situation is unique. So.
Merci.
Thank you. Mr. Leckie, would you have any comments as to the impact of incarceration, even if it's pre-trial, for those people who have mental health issues or have addictions?
I'm sorry, I don't quite understand the question, Mr. Chair.
What is the impact of keeping people detained when they have mental health issues or when they have addictions?
Well, thank you for the question. And there's no question that, the underlying issues that have led to bringing people into the police realm and the justice system have to be addressed. So social issues, including mental health and whatever other circumstances that people find themselves in, if we don't deal with those issues, then clearly we're not getting to the root of the problem, and we can expect that it will continue. Sometimes the advantage of it being in custody, though, is that's the only opportunity that people will get to have the treatment that they deserve. And, it's an unfortunate situation, but when we look at especially the circumstances we have here in the Northwest Territories and the territories throughout the North, is the lack of adequate supports in some of our rural and isolated communities. And when we try to solve some of the issues in our southern parts, bigger cities, my goal is to make sure we don't forget that what may work in the south may not always work in some of our rural northern provinces and certainly the territories.
Thank you. Thank you, Ms. Briard. Next we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you, Mr. Davis, Mr. Montour, and Mr. Leckie. In your view, we saw that Bill C-5 did away with a number of mandatory minimum sentences. There were other issues as well, but on that issue, in Quebec, we saw people refer to these changes to, in a way, question the seriousness of the offenses that they're charged with. And that actually is something that triggers something in me when we talk about these types of detention. You were mentioning earlier that a number of people use, these Gladue reports to try to influence the sentence that they could be given, and also to use that when it comes to their bail hearings. In your view, if you combine all of these issues, do you not think that that in some way influences the work of courts when they have to really administer any evidence as to these types of releases?
Allez-y, Monsieur Davis.
Go ahead, Mr. Davis.
Absolutely. If I'm understanding the question correctly, you're asking would having a scrutiny system in place or some sort of mechanism to scrutinize the claim of being Indigenous, would it impact the courts? Absolutely. It would be quite labor intensive. But I agree with Chief Montour's comments that there's nothing in place right now. And then to my earlier comment that once people identify, they will compound that by shopping for a JP that has a reputation for releasing people on Gladue considerations.
Parce qu'on a vu des...
Because in some cases, in some trials, the judges were concerned, or perhaps concerned is not the right word, but the judge would ask the lawyers to argue, given the fact that the legislator had abolished the mandatory minimum. So in order to determine what sentence to impose, well, okay, you'd say the legislator says this. What do you think? Well, the first question is, if we're talking about bail release, is that not still a relevant question? Do we not end up in situations where courts end up saying, hey, the legislator sent a signal, that triggering a firearm or using a firearm with intent is no longer the subject of a mandatory minimum, and that has an effect on the courts when they have to decide as to bail releasing someone on bail?
Yeah, I think I understand your question, sir. Looking at the way the courts work, and as far as Gladue for bail and mandatory minimum sentences, like we go to the bail first, they take into consideration the background of the person, specifically if they are Indigenous, previous charges, criminal records, and that all plays a fact whether or not release is going to be granted or conditions where the person remains in custody. As far as the mandatory minimums, from previous investigations I've been part of with mandatory minimums, say for firearms trafficking, there has to be some sort of a deterrent. And I know as of late there's conditional sentences imposed for firearms offenses. I don't agree with that, because then we have a repeat of certain serious crimes involving a firearm. And going forward, like we both brought forth examples of individuals who committed crimes in the past with firearms and violence being released, yet to commit the same sort of offenses on bail conditions. I hope that answers your question, sir.
Merci, Monsieur Montour.
Thank you, Mr. Montour. I'll take advantage of this opportunity, given the fact that you're both of Indigenous background. From what I gather, the minister was referring to C5 and the striking of some mandatory minimum sentences. The minister often says, there are too many racialized or Indigenous people in jails. Of course, we're all sensitive to that. No one wants to have a discriminatory system in place, but I always ask myself the question, why is it? Of course, the statistics are there, yes. It is true that there is a higher ratio of Indigenous people than non-Indigenous people in these jails. But the question is why? Is it because police officers are too strict with these individuals, or the justices or judges are too harsh? Or is it because there is a community service issue in the communities? I don't know. I'm not Indigenous, so I always have a difficulty understanding why, but we often hear that argument. So I'd like to hear your point of view on this. Why is it that statistically speaking, we have more Indigenous people in our jails than non-Indigenous people?
Thank you for the question, sir. I agree that there is that over-incarceration of Indigenous and other marginalized peoples in custody. But to me, that stems from a societal issue. In the case of Indigenous people, with the residential school system that was in place for over 100 years, like I speak specifically about the Mohawk Institute in Brantford, opened in 1831, closed in 1970. there's that intergenerational trauma that's been passed down. The language was lost, the traditions were lost. People forgot how to say I love you, and that's coming from survivors that I have spoken with who were in the Mohawk Institute. That leads to addiction, poverty, lack of education, and then those who were affected by that turn to crime. And it's sad to see, but we still have a responsibility to ensure public safety of our communities, because 99% of the time the offender is Indigenous and so is the victim.
Thank you. Thank you, Monsieur Fortin. Next, Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I'd like to particularly thank Chief Davis and Chief Montour for reminding us of the impact of the incidents like the murder, of course, Constable Pershala, on serving members and their families. I think it's important for all of us to remember that while these may seem exceptional, they're not exceptional to those in the policing community. So thank you for that important reminder today. I think most of us around the table have accepted that there's a need to tighten the bail system for certain people, that certain people get bail who should not. And so one of the things that certainly I've been looking at is the question of reverse onus on possessing a loaded firearm, because currently that's not a reverse onus offense for bail. So, Chief Davis, you gave us the example of someone who's found passed out and had a loaded weapon, ended up getting bail after that. If we reverse the onus on Section 95, it would make it much more difficult for people like that to get bail. Do you think that's one of the things that we could do to help tighten this up?
Absolutely. That's absolutely a consideration that needs to be taken seriously and implemented, is to have that reverse onus.
And Chief Montour, would you agree that that would make a real difference in the field if we made it reverse onus for loaded firearms?
Yes, it would, because more and more we're seeing mainly those trafficking in illicit drugs possessing handguns more. I grew up in a society where hunting was a way of life for Indigenous people, long guns, rifles, shotguns. And as of late, in the last year, maybe 2 years, every time our drug officers execute a warrant to search under the Controlled Drugs and Substances Act, there's a loaded firearm there, and it's a handgun, easily hidden in the waistband of those who are accused. And I agree that there should be a reverse onus on that section, because we don't need those individuals walking the streets in our communities with a loaded firearm, especially if they're under the influence of drugs or alcohol.
I think the second point that you raised today that's very important is the use of sureties. And I know I don't like to personalize things, but if you'd asked my mother, should I be out of jail, and she'd make sure I didn't do anything wrong, her answer would have been yes. And so, but I think the problem, certainly in my own community, is that we often lack any alternatives. And so we don't have good community-based bail supervision programs where a neutral party who is professionally trained could do bail supervision. And I guess I'll start maybe with Superintendent Leckie. Do those kind of bail supervision programs exist in the Northwest Territories? And then I'll ask each of you to respond to that.
Thank you for the question, Mr. Chair. They do exist, although not always, not often, as often used as could be. One of the factors when we talk about sureties, if we're talking about a financial surety, that can be a hardship on some of the folks we have in our communities. When you have other people who will step up as sureties, that is one of the areas that my colleagues and I have kind of noticed and expressed that there's opportunity to improve and perhaps tighten up some of the rules on, because currently there really is very little consequence when sureties, when people don't comply while out on a surety. So there are opportunities there to make that better, and that's certainly one of the areas I think, as noted in my opening comments, is available and supported by all of our colleagues.
And Chief Montour, in your case, are those programs available and used?
In cases involving offenders from the Six Nations of the Grand River community, those that are brought up for sureties, they're, like the superintendent says, hardship, and there's no cash deposit made. But yet, some of those folks who are designated as sureties should not be. there needs to be more consultation, mainly with the police service of jurisdiction.
And is there any kind of community-based bail supervision program available?
No, we don't have the manpower or the resources to do that, because I could allude to the commissioner statement back in the Ontario legislature. I feel, as Chief Davis does, the onus is on the offender to ensure they're abiding by the conditions. They made that promise prior to being released. And society looks at police. We're not babysitters.
But in terms of public confidence, I think we do see the public saying, but nobody is looking. And not even if the public doesn't understands police don't have the resources to do that, and they don't have that expectation, I think certainly we're hearing from a lot of people that somebody should be. Chief Davis in this case.
Yeah, thank you. Absolutely. What we've seen is with the increased release of people on bail conditions is effectively a downloading to the police services of jurisdiction to become professional babysitters, where there's a need. If we want that true supervision, there needs to be an entity, a body, whether that be community-based or similar to the the marshals in the United States, but there needs to be some sort of body that's their full-time job, is to do that, enforcing compliance, checking on compliance, and then when there's violations of compliance, ensuring that the breach charges are laid.
And do you think that would help with public confidence in the bail system overall?
I believe it would. I believe it would, because right now the society knows that we can't be babysitters and we can't be everywhere at once. We have other competing demands that require us to respond.
Great. Thanks very much. Thank you, Mr. Chair.
Thank you, Mr. Garrison. We're next, just in the interest of time, we're going to condense the round a little bit. It'll be Mr. Van Popta, and these will be 2 3-minute rounds, if that's okay.
Good. Thank you. Thank you, gentlemen, for being here. Chief Davis, Chief Montour, and Chief Superintendent Leckie. We really appreciate the work that you're doing, that your colleagues are doing. Frontline work can be very dangerous. And I'm thinking of Shaylin Yang from the RCMP in Burnaby, close to where I live. I didn't know her personally, but I know people who do, or who trained with her, so it's close to home. Now, Mr. Chief Davis, in your testimony, you told us what it's like for police officers, people on the front line, and how dangerous that work can be and how demoralizing it can be. Yet you were quoted as saying, and I think it was in one of the local newspapers, it's not the judge's fault. They're simply applying the Gladue rules. But now we refer to the McKenzie case. This is the person who is now accused of murdering Pershala. The judge said, I'm confident that the public would conclude that the current strict plan of house arrest supervised by the accused's mother with independent monitoring and counseling is a reasonable restraint on the accused's liberty until trial. Now, clearly, in retrospect, that was a bad decision. But was the problem with the Gladue principles or with the way the judge applied those principles?
Respectfully, Chief Montour knows a lot more details on this, so I'm going to pass this over to him first.
Fair enough. So let's go to Chief Montour then. Thank you.
Thank you, sir. It's kind of both. Like Justice Arell, I've sat before him in his court before. He's a very competent judge. And as far as the Gladue factors, I know that the Supreme Court has made this case law for sentencing as well as bail for, it's quoted as aboriginal offenders in the code. But I'll refer back to my question, my opening statement. If Randall McKenzie was not an Indigenous male, would he have been released from custody? I think not, based on his criminal history. He had a robbery with a firearm conviction where he assaulted the owner of a restaurant in Hagersville, whom I know as well as other firearms offenses. He assaulted a police officer in Hamilton, and he committed other crimes involving a firearm. And again, I say, race should not factor in to repeat serious offenses such as that and those offenders who are committing those crimes.
Okay, thank you.
Thank you, Mr. Van Popta. Next to Mr. Zaberi for 3 minutes.
I'd like to thank all the witnesses for being here today, and want to share with you that I was in the military and served in uniform once upon a time, and so respect what you do and the challenges you must be facing on the ground. I want to pick up on a line of questioning brought up by a colleague from the bloc around the high levels of Indigenous people in incarceration. And we talked a lot about the policing side. We touched upon the administration of justice and judges. Do you, in your opinion, where are judges at with respect to the understanding of who Indigenous people are, the challenges that they are facing, in particular around your domain when it comes to administration of justice?
To me, I'm not being detrimental when I say this to the justices at all. There needs to be more education on their part to understand specifically the community of Six Nations. There is a couple judges that sit in Brantford, Justice Edward, Justice Good, who are both of Indigenous background, and they understand it. And the Indigenous Peoples Court that is running in Brantford, I don't get called there as much as I used to, and I see that as a good thing because it's working. Whereas for more serious offenses, like I said earlier, the GLADU factors need to weigh less and public safety needs to be increased because that's our job. And as you know, wearing a uniform as well, public safety is paramount. And I've always said that. And I've always said to Justice Edward, he and I have had some debates in the past about the offenders have the GLADU case law. What do the Indigenous victims have in this community?
I hear what you're saying around GLADU, and I appreciate generally these types of conversations are with jurists and those who are legally trained, but you do work within the justice system. My understanding of GLADU, it's not an automatic, given that just because somebody claims systemic discrimination, be they Black, be they Indigenous or other backgrounds, that GLADU principles will lead to a lighter sentence. Isn't there some sort of analysis and filter that should be done? I know lawyers generally probably would dive deeply into this, but from your understanding, wouldn't there be some level of analysis to see if it applies?
I know that once a conviction is imposed, the judge will order a GLADU report where a GLADU writer will meet with the victim, the offender's family, the offender themselves to get the background. And don't get me wrong, as I stated before, GLADU does work in certain cases. It does, because I've seen it where there's people with addictions and mental health issues where they've gone through the system and they're allotted time prior to being sentenced that they seek the help that they need, and it works.
So just want to ask clearly, there would be some level of analysis.
Thank you. Thank you, Mr. Zaveri. That concludes our round, and I want to thank the witnesses. All of you are in law enforcement and first responders, so we really admire all your service, and we take your input very seriously, so thank you very much. I just have a couple real quick housekeeping for members. Travel budget, I think it's been given to everyone regarding the trip as resubmitted. I see a nice smile from Mr. Garrison, always appreciative of that. I just want to say if you're okay with that. And the second one was the study budget on bail system. I think it's the proposed budget for this study. Just seeing if I can see some heads nod that we're okay with this. Okay, yes, thank you. And we see Mr. Garrison's on the trip, that is, right? Yeah, not on the other one, yes. Okay, okay, thank you. That concludes. We'll see you on Wednesday. Thank you. Adjourned. No problem.
you.